code, production orders, wiretap authorizations. Let's just pause there and take those four.
Sure.
In order to obtain any of those four warrants, the application must be supported by an information on oath, usually by a police officer, or an affidavit. I don't know why, but Parliament chooses to use the terms. They mean the same thing, basically. It's an affidavit in a wiretap authorization. It's an information to obtain in a search warrant. They are sworn statements under oath in which the deponent sets out investigative detail sufficient in his subjective belief to justify the court in issuing the warrant that would permit the police, say, to enter someone's home and search for money.
Right.
I said the police officers or the deponent's subjective belief.
Right.
There are two elements. There must also be an objective basis on which to justify issuing the search warrant. But of course, the police officer who's swearing under oath will also depose to his subjective belief that the issuance of this warrant is necessary in the investigation and that they expect evidence will be found at the location specified in either the warrant or the production order or the other two examples that I gave. A production order is usually used to obtain or to seize something specific that's in a known place, such as a financial institution producing banking records.
Right.
I just had that in a large mega case that concluded recently, and production orders are being used more and more often by law enforcement to obtain financial information, as an example.
Now, let's say that you get that. Then, okay, you get this ITO, or you get the related documents from a wiretap or something like that. And again, obviously, these are incredibly detailed documents. I mean, you'd agree with me that the ITOs can sometimes go for dozens of pages, or perhaps even longer in a large-scale commercial thing like that.
I've seen wiretap affidavits that are almost 1,000 pages.
There you go. And I haven't, right? I mean, which is why we're interviewing you and not me, right? Just what's the general way that a lawyer would approach that? Let's assume they're not getting a 1,000-page wiretap right away, okay? But one thing that especially if you're out in the sticks, if you're out in rural, you could easily find yourself on, let's say, a grow-up or something like that, right? What is the process from a defense perspective? And I'm talking mainly about the concepts of amplification and excisation on the ITO. How, in the context of a Garofoli application, just generally, how does that work, and what is that?
Very generally, and in a very broad stroke. What you're talking about is a charter application,
right?
And usually, that doesn't foreclose that there could conceivably be applications that relate more to a specific section of the criminal code.
Right.
But broadly speaking, the application is under Section 8 of the Charter,
right? Because
the defense is taking the position that the information that's contained in the affidavit or the ITO was insufficient, on the basis of which the judge who issued the search warrant could have done so.
Right.
And therefore, the search that was conducted is unreasonable
Right.
and in breach of Section 8, which is the guarantee in the Charter against unreasonable search and seizure. That then triggers what you called a Garofoli
Yes.
application in the courts,
Yep.
which is simply the name of the case that governs
Right.
the test that the court will apply in determining whether the ITO disclosed sufficient grounds on the basis of which the issuing judge could have issued the warrant or the ITO. If the trial judge, or what we call the reviewing judge in court, says yes to the application, that there was insufficient information, reliable information before the issuing judge, that court would then find a breach of Section 8 of the Charter, and the hearing would then progress to the second stage, and that is whether the evidence obtained by the execution of the warrant should be excluded from the trial. That's the broad picture.
Right. And I mean, there are literally entire textbooks written on search and seizure, written on search warrants, and written indeed on wiretaps. So, I mean, that probably is all that reasonably I can expect to cover on that. I mean, I'll run out of the battery on the camera will die. You know, it's as simple as that. You know. So, Clayton, I really appreciate you taking the time to help out younger lawyers. For those of you that don't know it, Clayton actually made a reference to what we used to call a library. Libraries used to have these things called criminal reports in Canadian criminal cases, where you would read like head notes and articles on criminal law. Clayton now does this for free on his blog. It is easily one of the best blogs I personally have ever seen. It is very detailed analysis. Clayton lectures the defense bar, and I believe he also teaches a great deal. You're a professor too, aren't you?
Well, I have in the past,
right.
not
recently.
today as
No.
I have previously.
No. But again, he's an absolute wealth of resources. I'm gonna, in the YouTube channel, I'm going to link to his blog, and absolutely wealth of resources. And you know what, Clay? Thanks so much for taking the time to do this, and thank you for
My
your help,
pleasure,
sir.
Alan.
Awesome. Thanks, Clay. You have a good day.